Legal English course. This course is designed for both students of law and teachers of law, and even for practicing lawyers who wish to improve their level of English. It is suitable for those who wish to work in an international legal environment and need to extend their language skills to be able to read and understand English in a legal context and to communicate effectively, both orally and in writing, and for students who would like to pass effectively and successfully ALNOT course or exam and even the other legal English exams. So this course provides practice in all languages, skills, and uses a variety of legal text types and situations to provide stimuli for tasks and to develop a range of vocabulary, including collocations, phrasal verbs, word formation, and formal and informal equivalents. You are familiar with that. Many sections of the units of this course give integrated skill practice by developing a thematic link, though the language is frequently recycled in various contexts. So many tasks and information also assist develop certain legal skills at the same time as giving linguistic practice. This course covers the main legal areas studied in international law. And let's get started to talk about multiple choice. For this part of the ALMA test or legal English test, candidates read a complete text and then answer questions about it. Each question has four possible answers. To find the correct answers, candidates need to understand the text very well and differentiate between subtle and often similar opinions, reasons, or results expressed in it. Candidates need to remember that there will be distraction in the text. Surely, this means that there will be some information in the text that links with the wrong options. It is a good idea to read the whole text through before looking at the text questions, but this is just a, an idea. But I highly recommended you to go through your questions, then go back to your reading passage. Now, let's go to our industrial property or intellectual property. In broad terms, protects inventions and includes patents to protect inventions in industrial designs. In addition, it covers trademarks, service marks, layout designs of integrated circuits, commercial names and designations, as well as geographical indications and protection against unfair competition. Copyright, also known as author's right in most European languages, relates to artistic creations such as books, music, paintings, and sculptures, and films and technology-based works such as computer programs and electronic databases. While the expression copyright refers to the main act, that act is the making of copies of the work, whereas the expression author's rights relates to the creator of the artistic work, namely its author. The author has certain specific rights in his creation, which only he can exercise, such as the right to prohibit or authorize its reproduction, distribution, performance, communication to the public, translation, or adaptation, and these are recognized in most laws. Other rights, such as the right to make copies, can be exercised by other persons, where permission or a license has been obtained from the author. A created work is regarded as protected as soon as it comes into existence. Copyright ensures the protection of the author's rights and provides remedies for the author in the event of any infringement. Essentially, copyright protects the form of expression of ideas, whereas in the context of industrial property or intellectual property, inventions can be considered as new solutions to technical problems, and these solutions are ideas and are protected as such. In fact, protections of inventions under patent law does not require the invention to be actually physically in existence. The difference between inventions and literary and artistic works give rise to different degrees of legal protection, as protection for inventions gives a monopoly over the right to exploit an idea. The duration of such protection is usually about 20 years, which is quite short. On the other hand, the protection of literary and artistic works prevents unauthorized use of the expression of the ideas, so the duration of the protection can be much longer. Furthermore, the public must be made aware of the fact that the invention is protected, and this is done publicly through disclosure in an official register, whereas a created work is considered protected as soon as it exists, and a public register of copyright is not required. So let's read this extract to understand what is that intellectual property. Domestic legislation enacted within countries ensures intellectual property protection for two reasons. First and foremost, to give statutory expression to the moral and economic rights of creators in their creations, and also to the rights of the public in assessing those creations. And the second is to promote creativity and the dissemination and application of the results, and to encourage fair trade, thereby contributing to social and economic development. So the division of intellectual property into distinct legal categories, namely industrial property and copyright, results in different rights, duties, and obligations, giving rise to varying degrees of protection and enforcement. Now you have the overview of the intellectual property, and we do have here some three questions relating to this article. First one, what two reasons are given to ensuring intellectual property protection? So our answer is to give statutory expression to the moral and economic rights of creators in their creations, and to give statutory expression to the rights of the public in assessing those creations. And another one, to promote creativity and the dissemination and application of the results of such creativity, and to encourage fair trade. The next one, what are the two legal categories mentioned? The two legal categories mentioned are industrial property and copyright, based on our previous pitch. And the last one is, why does the article mention these two categories? They give rise to varying degrees of protection and enforcement. So, we need to read the whole article again and answer these questions. First one, what's the difference between the expression author's rights and copyright? So, author's rights relate to the creator of work. Copyright refers to the act of making copies of the work. The next one, does an invention have to exist to be protected? Actually, no. The invention does not have to be physically in existence. And the next one, why does the duration of protection for industrial property and copyright differ? Actually, protection for an invention gives a monopoly right to exploit an idea. So the duration is about 20 years, because it is only the exploitation of the idea that is protected. And copyright, at the same time, protection, on the other hand, prevents unauthorized use of the expression of the idea, so the duration of protection can be much longer. The next one. How is the public made aware that invention is protected? I consider through registration of the invention. And the final one. Why is there no need for a register of copyright? Because the created work is considered protected as soon as it exists. So let me wrap up. In this video lesson, you have learned the key features of the intellectual property. Then you have also had an overview of the main industrial property and copyright difference. And I imply that you have an overview of this lesson. So that's all for this lesson. Wait for the next video lesson for the legal English. Do not forget to like, comment, share, and subscribe to my channel for more education video lessons, materials, resources for students and teachers. Enter your email into the comment to send you interesting, updated, and fresh information, materials, and lessons.